It starts with a flicker of blue and red lights in your rearview mirror, a sight that makes your stomach drop no matter how many years you have been driving. You check your speedometer. You check your seatbelt. You pull over to the shoulder, your mind racing through the mental checklist of where your registration is and whether your insurance card is current. But for millions of Americans, there is another thought that overrides everything else in that moment. The firearm sitting in the glove box, the center console, or the holster on their hip. For lawful gun owners, a routine traffic stop isn't just an inconvenience. It is a high-stakes interaction where one wrong move, one misunderstood sentence, or one nervous gesture can escalate a $50 ticket into a life-altering legal crisis. And until very recently, the legal ground beneath those stops was shifting in a dangerous direction. Courts across the country were beginning to treat the mere presence of a gun as a green light for law enforcement to bypass your Fourth Amendment rights. But a unanimous Supreme Court decision just changed the rules of engagement. 9 justices, 0 disagreement, drawing a line in the sand that directly affects every single driver who legally carries a firearm in their vehicle. And here is the part that should stop you cold. Most people won't hear about this ruling until after it matters, until they are already standing on the side of the road, watching an officer toss their belongings onto the pavement, wondering how a lawful act turned into a roadside search. Welcome to U.S. Green Card Signal. I am Edward, and today we are going to have a conversation that could save your freedom, your property, and your peace of mind. We are dissecting a legal shift that is flying under the radar but has massive implications for anyone who values their privacy and their Second Amendment rights. We are talking about the Supreme Court's definitive statement that lawful gun ownership is not, by itself, suspicious activity. On the surface, this sounds like a massive win for civil liberties, and it is. But underneath the headline is a complex web of conditions, limits, and pressure points that can completely flip the outcome against you if you don't know exactly how this works in the real world. There are specific moments during a traffic stop where this decision can shut down an intrusion instantly, and there are moments where one sentence from you can make it useless. So, before you find yourself trying to argue constitutional law on the shoulder of a highway, you need to understand exactly what just changed, and more importantly, what didn't. To understand why this ruling matters as much as it does, you have to understand the tension that has been building for years beneath the surface of American policing. On paper, your rights are very clear. The Second Amendment gives you the right to keep and bear arms. The Fourth Amendment protects you from unreasonable searches and seizures. These are foundational pillars of American liberty. They are not supposed to be in conflict. You shouldn't have to trade your privacy to exercise your right to self-defense. But out on the road, in the dynamic and often tense environment of a traffic stop, those two rights started colliding in a way that created a serious legal problem. The question that kept coming up in courtrooms was simple. Does the knowledge that a gun is present in a car give police the automatic right to search that car? For a long time, the answer was becoming a murky maybe or even a dangerous yes. Some lower courts began building a legal theory that treated firearms as inherently dangerous, and therefore, their presence created an inherent exigency, an emergency situation that justified bypassing the warrant requirement. The logic went like this. Guns are dangerous. Police officer safety is paramount. Therefore, if a gun is present, the officer must have the authority to secure the scene, which could include searching the vehicle to ensure no other weapons are within reach. While that sounds reasonable as a safety precaution, in practice, it was morphing into a loophole that swallowed the Fourth Amendment whole. It meant that exercising your Second Amendment right effectively canceled out your Fourth Amendment protection against warrantless searches. It created a class of citizens who had fewer privacy rights simply because they chose to be armed. This legal drift wasn't just theoretical, it was playing out in real stops every day. A driver would get pulled over for a broken taillight. They would responsibly inform the officer they had a permit and a firearm, and instead of a "thank you for letting me know," they would find themselves ordered out of the car while the officer tore through their trunk, looking for, well, anything. No evidence of a crime, no suspicion of illegal activity, just the gun. This pattern was normalizing the idea that lawful gun owners were second-class citizens when it came to privacy. And that is exactly what the Supreme Court stepped in to stop. The case that reached the High Court wasn't a high-profile shootout or a terrorism investigation. It started, as most of these landmark cases do, with something incredibly mundane: a driver, a traffic violation, and a firearm. The details are familiar to anyone who carries. The driver was stopped, the presence of the firearm became known, and the officer used that fact, and that fact alone, as the justification to search the vehicle. The driver challenged the search, arguing that since possessing the gun was legal, it couldn't be the basis for probable cause to search for evidence of a crime. The lower courts disagreed, siding with the officer's safety concerns. But when it got to the Supreme Court, the justices looked at the facts and came to a conclusion that was stunning in its clarity and unity. 9-0. Every justice, from the most conservative to the most liberal, agreed on a single principle: the mere presence of a legally possessed firearm in a vehicle does not by itself establish probable cause to search that vehicle. They drew a hard line. They said that lawful conduct cannot be the sole basis for suspicion. You cannot presume a crime is being committed just because a citizen is exercising a constitutional right. This ruling is a shield. It stops the automatic gun equals search equation that was taking hold in law enforcement. It reaffirms that the Second and Fourth Amendments are meant to coexist, not compete. However, and this is the however that will get you in trouble if you stop listening now, this ruling is not a magic wand. It is not a force field that repels police officers. It is a legal standard with very specific boundaries. The most important phrase in the entire ruling is "by itself." The court said a gun alone is not probable cause. They did not say a gun can never be part of probable cause. And that distinction is where the real-world game is played. This is where we get into the trapdoors, the three specific ways that this protection can evaporate before your eyes. Trapdoor number 1 is the definition of lawful. This ruling protects lawful gun owners. That word is doing a lot of heavy lifting. If there is any question about your legal status to possess a firearm, the entire analysis flips. If you are a prohibited person, someone with a felony conviction, a domestic violence restraining order, an active warrant, or an involuntary mental health commitment, the presence of a gun is not lawful conduct. It is a felony in progress. In that scenario, the gun absolutely establishes probable cause because its very presence is the crime. But it goes deeper than that. What if you are generally allowed to own a gun, but your permit has expired? What if you are carrying in a state that doesn't recognize your home state's permit? In those moments, you are not a lawful gun owner in the eyes of the officer. You are a suspect illegally possessing a weapon. The Supreme Court shield vanishes instantly. This means that your first line of defense isn't the Constitution. It's your own administrative housekeeping. Keeping your permits valid, knowing which states honor them, and ensuring you aren't disqualified is the prerequisite for any of this legal protection to apply. Trapdoor number 2 is compliance with storage laws. This is where well-intentioned people get criminal records. Legality isn't just about who you are, it's about how you carry. Every state has a patchwork of laws regarding how a firearm must be transported in a vehicle. In some states, like Texas or Florida, having a loaded handgun in your glove box might be perfectly legal without a permit. In other states, like California or New Jersey, That same act could be a felony depending on the specific circumstances. Some jurisdictions require the gun to be unloaded and locked in a separate container from the ammunition. Others require it to be in plain view. Others require it to be concealed. If you are driving through a state and you violate their specific storage law, even if you have a valid permit to own the gun, you are breaking the law. And if an officer sees a gun stored illegally, that observation provides probable cause to search the rest of the vehicle. The officer doesn't need to guess. They see a violation. The Supreme Court ruling doesn't help you here because the conduct isn't lawful. This is why ignorance of the law is such a dangerous vulnerability. You might think you are protected because you are a good guy with a gun, but if your gun is under the seat when it should be in the trunk, you have just handed the officer the keys to your car, legally speaking. Trapdoor number 3 is the most subtle and the most commonly used: the totality of the circumstances. The court said a gun alone isn't enough. So, what do officers do? They find something else to add to the equation. They build a stack of bricks until they have a wall of probable cause. The gun is one brick. But then they add, the driver appeared excessively nervous. The driver's hands were shaking. There was a faint odor of marijuana. The driver's story about where they were going didn't make sense. There was a lot of movement in the car before I approached. Individually, maybe none of these things justify a search. But when you combine them, a gun plus nervousness plus a weird story, the officer argues that the totality of the situation suggests criminal activity. The gun becomes just one piece of the puzzle, a contextual clue rather than the sole reason. And courts often defer to an officer's training and experience in connecting these dots. This means that even with the Supreme Court on your side, your behavior, your demeanor, and the condition of your vehicle are still critical factors. If you give the officer other reasons to be suspicious, the gun will simply be the cherry on top of the probable cause sundae. This brings us to the most dangerous moment of any traffic stop, the moment that overrides Supreme Court rulings, constitutional amendments, and legal precedents. It is the moment of consent. An officer might look at you and ask, "Do you mind if I take a look inside your vehicle?" It sounds polite. It sounds casual. It is framed as a request, not an order, and that is exactly why it is so effective. Human psychology drives us to cooperate. We want to show we have nothing to hide. We want to de-escalate. We think that saying no makes us look guilty. But legally, the moment you say yes or sure or go ahead, you have waived your Fourth Amendment rights. You have given permission. It no longer matters if the officer had probable cause. It no longer matters if the gun was the only reason. You open the door. Officers are trained to seek consent because it is the golden key. It bypasses all the complex legal analysis we just talked about. If you consent, the search is legal, period. And they will use psychological pressure to get it. They might say, "If you're honest, you shouldn't have a problem." Or, "I can call a dog out here, it'll just take longer." These are tactics designed to make you fold. But you need to understand this. Refusing a search is not an admission of guilt. It is the assertion of a right. The Supreme Court has ruled on this too. You cannot be punished for exercising a constitutional right. Saying, "I do not consent to a search," does not give them probable cause to search. It maintains the status quo. It forces them to either come up with a legal justification on their own or let you go. This is the hill you have to be willing to stand on. So, let's move from the legal theory to the pavement. What does a perfect traffic stop look like for a lawful gun owner in light of this ruling? How do you behave to maximize your protection and minimize your risk? It starts the second you see the lights. Don't panic. Signal, pull over safely to the right, and stop. Put the car in park, turn on your dome light if it's night. Roll down your window, and if you have tinted windows, roll them all down. This is about officer safety perception. You want to make the environment as transparent as possible. Then, Put your hands on the steering wheel at 10 and 2. Open hands, clearly visible. Do not reach for your wallet. Do not reach for your glove box. Do not dig around under the seat. Movement kills. In the officer's mind, furtive movement is a precursor to an ambush or an attempt to hide evidence. Just sit and wait. When the officer approaches, be polite but guarded. Good evening, officer. When they ask for your license and registration, this is the critical communication point. If your gun is in the same location as your documents, or if you are in a duty-to-inform state, a state where you are legally required to tell police you are armed, you speak first. Officer, I have a permit and I am carrying a firearm on my right hip. My wallet is in my back pocket. How would you like me to proceed? You are taking control of the information flow. You are eliminating the surprise. You are asking for instructions before you move your hands toward a weapon. This de-escalates the tension immediately. But then comes the fishing expedition. Where are you coming from? Where are you headed? Do you have anything illegal in the car? These questions are designed to get you talking, to trip you up, to find inconsistencies. You do not have to give your life story. You can answer politely, but vaguely. I'm just heading home, or I'd prefer not to answer questions unrelated to the stop. You have the right to remain silent, and you should use it judiciously. You don't have to be a jerk about it, but you don't have to be a chatty open book either. Then comes the big question. Can I search your car? Your answer must be scripted and automatic. Officer, I respect your job, but I do not consent to any searches. If they push back, you repeat it. I do not consent to a search. If they search anyway, do not physically resist. Do not fight on the side of the road. Step back, shut your mouth, and let it happen. State clearly, I am not resisting, but I do not consent to this search. This preserves your legal standing. If they find something, or if they just toss your car for no reason, your lawyer will have a field day with the body cam footage because you clearly refused consent. You win in the courtroom, not on the roadside. We also have to talk about the Terry frisk aspect, which is a nuance often confused with a full search. The Supreme Court allows officers to conduct a limited pat-down of a person, a frisk, if they have reasonable suspicion that the person is armed and dangerous. Note the and. Being armed is lawful. Being dangerous is different. However, officers often conflate the two. They might order you out of the car for safety. This is legal. Pennsylvania versus Mims established that officers can order drivers out of the car. If you are out of the car and you are armed, they may temporarily disarm you for officer safety during the stop. This is a gray area that varies by circuit court, but generally, courts have allowed officers to secure a weapon during a stop to ensure everyone goes home safe. This is not the same as searching your car for drugs. Handing over your weapon temporarily, if ordered to do so, does not give them permission to tear apart your back seat. Knowing the difference between a safety seizure and an evidentiary search is crucial. There is one more layer to this that is absolutely vital for travelers: reciprocity and interstate travel. The Supreme Court ruling is federal law, but gun laws are state laws. The moment you cross a state line, the rules of the game change. A permit that makes you a lawful gun owner in Pennsylvania might be a worthless piece of plastic in New Jersey. If you cross that invisible line, you transform from a law-abiding citizen into a felon in possession of a firearm. In that scenario, the Supreme Court ruling offers you zero protection because your possession is no longer lawful. This is the biggest trap for travelers. You must know the laws of every single state you drive through. You need to know the reciprocity maps. You need to know the Firearm Owners Protection Act, FOPA, Safe Passage Provisions, which theoretically allow you to transport a gun through a restrictive state if it is unloaded, locked, and inaccessible. But in practice, getting pulled over in New York with a gun is often a one-way ticket to jail, regardless of federal protections. Ignorance is not a defense. So, let's synthesize this into a survival guide. The Supreme Court has handed us a powerful tool. They have affirmed that the Second Amendment is not a second-class right. They have stripped the police of the ability to use your gun as a blank check to search your car. But that tool only works if you use it correctly. It works if you are lawful. It works if you are compliant with technical storage laws. It works if you do not give consent. It works if you keep your cool and don't give them totality of the circumstances ammunition. Ultimately, the responsibility falls on you. The system is designed to find reasons to investigate. Your job is to give them absolutely nothing to work with. You drive a clean car. You obey traffic laws. You keep your permits current. You know the laws of the states you visit. And when those blue lights flash, you enter professional mode. You are calm, you are compliant with orders, but you are firm on your rights. You don't have to choose between your safety and your privacy. You don't have to choose between your gun rights and your Fourth Amendment rights. But you do have to be smart enough, disciplined enough, and educated enough to assert them effectively. The Supreme Court just gave you the high ground. Don't surrender it because you got nervous, because you didn't know the local law, or because you fell for a friendly request to search. This is U.S. Green Card Signal. Our mission is to navigate the complex intersection of laws, rights, and real-world scenarios that affect you. We believe that an informed citizen is the most effective check on government overreach. If you found this breakdown valuable, if it clarified something you were unsure about, or if it just gave you a script to use when your mind goes blank in a stressful moment, then we have done our job. Share this with the people you care about, your spouse, your kids who are starting to drive, your friends who carry, because rights are like muscles. If you don't exercise them, they atrophy. And if you don't know you have them, you effectively don't. Stay safe, stay legal, and stay educated.